Hello friends, welcome to VSP Law channel. Thank you for clicking this video. Today we are going to discuss the a landmark judgment of the Honorable Supreme Court of India regarding the demonetization of the currency in 2016. So, judgment delivered by the Supreme Court India on 2nd January 2023. So, the 5 judges consisting of the Justice S. Abdul Nazir, Justice B.R. Gavoy, and Justice A.S. Bopanna, Justice V. Rama Subramaniam, and B.R. Nagaratna. So, this Constitution Bench delivered judgment held that the demonetization of currency is a valid one. So, it is upheld by the Honorable Supreme Court India by ratio of the 4.1 majority. So, 4 judges were favored and one judge, Justice B.R. Nagaratna, is dissented view held by the 4 members that though demonetization is a well intentioned or well thought of, it is has to be declared unconstitutional on legal grounds and of objects not achieved. So the B.R. Nagaratna is dissented view means is oppose the decision taken by the 4 judges. She is stating that the demonetization process is not a proper thought and it is a well intentional one and it has been declared as a unconstitutional on legal grounds. So the majority was given a favor judgment for union government, that is the demonetization is a valid one. So there is no objection today onwards. So it is a big success to the union government of India. So we are going to discuss the case in detail. So the case is already told that Vivek Narayan Sharma versus Union of India and others, along with 58 petitions filed against the decision of demonetization of currency taken by the Union Government India in 2016, dated November 8, 2016, by Gazette notification that the currency of the 500 rupees and 1000 is a banned by way of the demonetization. So the contention of the petitioner that the demonetization process is not done properly, it is not follow the procedure, and it is a unconstitutional one. And in petitioner Chidambaram also be one of the petitioners is there. So then the Honorable Supreme Court reserved the judgment on December 7, 2022, and January 2, 2023 given a judgment. So the court stated that so the demonetization process is a correct one and it is a well consultation by the union government with the RBI. The full judgment, the by judgment, reading the judgment by the B.R. Gawai stated that the demonetization had a reasonable nexus with the objects. Here the object is that eradicating the black money, terror funding, and etc. This object is sought to be achieved. So he further stated that it is not relevant whether the objective has been achieved or not. He added, we are Gawai. Justice. So that concluded the judgment that the central government as a consulted the RBI more than 6 months, and where the consultation took place, and the government had already opened a window for exchange of the old currency for the period of 52 days. So this is a correct process, and the court also be pointed that in the 1978 only 3 days were given for exchange of the currencies, and it is a extended further 5 days. So now the government has given union government given a 52 days for exchange of the money. It is a good process, and the decision taken by the Union of India in demonetization of currency is a economic policy. The judiciary has not intention to interfere the economic policy of the union government. So it is not a unconstitutional. It is a constitutional one, and the steps taken by the government is a proper one. Under section 26 subclass 2 of the RBI Act, empower the central union government to demonetization the any series of the current bank notes as a demonetization process. It means the section RBI Act section 26 subclass 2 clearly empowers the central government to demonetize the bank notes. So as per that section, the Union of Government India demonetize the 500 rupees and 1000 rupees as a band, and also be 52 days given for exchange of the currencies. So this is a judgment and a landmark judgment given by the Honorable Supreme Court of India. Today onwards there is no objection, there is no against anything. So the demonetization of the currency of Indian rupees was a valid one, and it satisfies the proportionality, and the court does not interfere into the economic policy of the Union of India. So this is a judgment today, friends. I think you satisfied. Then you will give the like, share, subscribe. Please don't forget to subscribe to my channel. Then I will give a judgment as early as possible by uploading a video. Please support me and please forward to the social media. If anything you want to may mention in the comment box. I am the V.S.Patel, V-Velumula, V.S.Patel, VSP Law channel. Thank you watching for one and all, and also once again wish you happy new year. Thank you one and all.